이제 행사를 시작하겠습니다. 모두 착석하여 주시면 감사하겠습니다. 이제 바로 행사를 시작하겠습니다.
We will begin the conference.
Good morning, everyone. Welcome to the 2022 International IP Court Conference. 안녕하십니까? 2022 국제 특허법원 컨퍼런스에 오신 것을 환영합니다. I am 성진구, Judge of Patent Court of Korea. I'll be leading you through today's program. This year marks the 8th anniversary of the International IP Court Conference, and it's a great honor and pleasure for me to welcome all of you here. 저는 오늘 개회식 사회를 맡은 구성진 판사입니다. 올해로 국제특허법원 컨퍼런스가 제8회째를 맡게 되었습니다. 이렇게 큰 국제 행사에 이 자리에서 여러분을 뵙게 되어 영광입니다. The conference aims to serve as a venue for judges and IP experts around the world to share their expertise and enhance mutual understanding. In particular, we came up with various sessions to discuss major IP issues, in-depth understand of theme of court IP and new practice as we are moving on from COVID-19. 본 컨퍼런스는 세계 IP 전문 법관과 전문가들이 경험을 공유하고 상호 이해를 촉진하기 위해 마련되었습니다. 올해는 Court IP and New Practice라는 주제하에 코로나19 극복 과정에서 지식재산권에 관한 실무를 심도 있게 토론해보고자 여러 세션을 구성하였습니다. Today we are joined by the most prominent judges and experts in the field of IP litigation. Judges and IP experts from 7 countries are joining us. 오늘 이 자리는 특허 소송 분야에서 가장 명망이 있는 법관과 전문가들이 함께 하였습니다. 전 세계 7개국에서 온 법관과 IP 전문가들이 참석해 주셨습니다. I'd like to ask for your kind understanding for not introducing each of participants due to time constraints. 시간 관계상 일일이 소개해 드리지 못하는 점을 양해해 주시기 바랍니다. On behalf of the Patent Court of Korea, I'd like to extend my deepest gratitude to all speakers and participants for joining us this morning. 주최 측을 대리하여 오늘 이 자리에 함께해 주신 발표자분들과 참석자분들께 깊이 감사드립니다. Now I would like to invite Honorable Chief Judge Yong-seok Kim of Patent Court of Korea, the hostess of this event, to deliver his opening speech. 다음은 본 컨퍼런스를 주최하는 한국특허법원의 김용석 법원장님의 개회사가 있겠습니다. Please welcome him with a big round of applause. 김용석 법원장님을 큰 박수로 모시겠습니다.
네, 여러분 안녕하십니까?
Good morning, everyone.
2022년 제8회 국제 특허법원 컨퍼런스에
I would like to
참석하신
thank everyone
여러분을
for taking
환영합니다.
part in the 2022
먼저
8th
본행사를
International
전적으로
IP
지원해
Court
주시며
Conference.
축하 영상을 보내주신 김명수
First of all, I'd like to
대법원장님,
thank Chief Justice
귀중한
Kim Yong-seok
시간을
for his
내어 본
congratulatory
행사
video,
현장에
and
직접
also
참석해주신
I'd like to thank
세계
Professor
특허법과
Hwang
추진위원회
Young Lee, the joint
이광영
chair of the Global
공동대표님,
Patent Hub Committee, for
평소
taking time out of your
지식재산권의
busy
발전을
schedule
위해
to be
많은
with us
노력을
today.
아끼지 않으시고
And
오늘 행사를 위해 동영상으로
I would
축사를
also like
보내주신
to thank
국제지식재산권기구의
Wipers,
조진슨 사무차장님,
Jorgensen Deputy Secretary General, and the President Nakatomi of LESI, and President Okuyama from AI, PPI, and President Pistolesi of FICIP, and President Vink of INTA for your congratulatory messages. In addition, I would like to thank Judge Kathy Vissoon and Judge James Meller, Judge Kumiko Katsumata, Judge David Bernstein, and lawyer Sasha Kress, as well as all the IP specializing judges and practitioners taking part via online. This year marks the 8th year of the International IP Court Conference. It is held to allow for in-depth discussions on various issues surrounding the global IP litigation field. This year's conference theme is Court IP and New Practice. We are in the process of overcoming COVID-19, and we have invited some of our overseas panels to Korea this year. Also, the recent IP trends, the Unfair Competition Prevention Act, the Trademark Act, and the session on calculating damages, all of these will be subjected to in-depth debate as well. Based on this, we will conduct a moot trial and apply what we have learned. In keeping with the theme of new practice, we have organized today's conference format as such. In this year's conference, judges and lawyers from the US, UK, Germany, Japan, China, and Australia and Korea will gather together to benefit from this precious opportunity to share our knowledge and insights. Also, I hope that this conference will serve as an opportunity to further strengthen the international network among IP judges and experts from across the world. I would like to once again express my deep gratitude to the moderators of each sessions and presenters for all the efforts you have put into today's event. And also my thanks goes to all the participants who have taken time out of busy schedules to be with us today. Thank you very much.
네, 법원장님 감사합니다.
Thank you
Now
for
we are
your
going to
remarks.
watch a congratulatory message from Honorable Chief Justice Myung-soo Kim of Supreme Court of Korea, who is not able to attend due to other commitments. 다음은 오늘 행사를 축하해 주시는 김명수 대법원장님의 축사가 있겠습니다. 대법원장님께서는 일정상 참석하지 못하셨지만 이번 행사를 축하하는 마음을 담은 동영상을 보내주셨습니다. 함께 시청하도록 하겠습니다.
이는 전 세계 지식재산권법 분야의 발전을 위해서도 매우 뜻깊은 일입니다. 이번 컨퍼런스에서는 코로나19 극복 과정의 일환으로 해외 패널 중 일부는 현장에 직접 참석하고 있습니다. 멀리서 오신 미국의 캐시 비순 판사님, 영국의 제임스 멜러 판사님, 일본의 쿠미코 카츠마타 판사님, 미국의 데이빗 번스타인 변호사님, 독일의 사샤 프레스 변호사님께 깊이 감사드립니다. 그리고 온라인으로 참가하는 호주, 중국, 영국, 독일, 일본, 미국의 법관들과 전문가들께도 감사의 말씀을 드립니다. 아울러 알차고 유익한 행사를 마련하기 위하여 애쓰신 특허법원 김용석 법원장님을 비롯한 관계자 여러분의 노고와 헌신에 경의를 표합니다. 제가 한때 몸담기도 했던 특허법원은 공정한 재판을 통한 지식재산권의 실질적 보호를 사명으로 하는 곳입니다. 지식과 상상력이 경쟁력의 원천이 되는 지식기반 사회에서 과학기술의 발전에 따라 지식재산권의 중요성도 점점 커지지만 분쟁도 나날이 복잡해지고 있습니다. 이러한 분쟁 해결을 위한 지식재산권 재판은 그 특성상 과학기술에 대한 깊은 이해는 물론 사회현상에 대한 통찰력과 함께 비교법적인 연구도 꼭 필요합니다. 여러 국가의 훌륭한 법관과 전문가들이 탁월한 식견과 풍부한 경험을 공유하고 활발한 토론과 교류를 하는 이번 행사의 결과물은 각국에서 더 좋은 지식재산권 재판을 위한 초석이 되리라 확신합니다. 코로나19의 위기에도 계속된 국제특허법원 컨퍼런스는 올해 IP, Court and New Practice라는 주제를 제시하였습니다. 코로나19 극복 과정에서 과학기술과 법에 관한 깊은 성찰을 토대로 실무에 실질적 도움이 되는 주제를 대상으로 지식재산권에 관한 새롭고 심도 있는 논의를 하는 것은 내용과 형식 면에서 새로운 방향을 제시하는 것입니다. 더욱이 세계적으로 사상 유례없는 고난과 역경을 초래하던 코로나19 대유행의 종식이 조심스럽게 전망되기에 이른 이 시기에 부정경쟁 행위와 상표 사건의 각 주요 쟁점들, 특허권 침해로 인한 손해액 산정 방법과 절차 등 구체적이고도 실무적인 주제에 대한 이번 논의는 코로나19로부터의 회복과 새로운 시대로의 준비를 위한 매우 시의적절하고 유익한 것이라 생각합니다. 독립된 법관이 공정하고 충실한 심리로 정의로운 결론에 이르는 좋은 재판이 대한민국 사법부의 헌법적 사명이자 국민의 신뢰를 얻는 유일한 길입니다. 이는 다른 나라도 다르지 않다고 믿습니다. 한 가지 소리는 아름다운 음악이 되지 못하고 한 가지 색은 찬란한 빛을 이루지 못하며 한 가지 맛은 진정한 맛을 내지 못한다는 고대 언어 철학자의 말이 있듯이 현장과 온라인 등 지리적 거리와 참가 방식에 구애받지 않고 전 세계 법관과 전문가들이 모여 진행하는 이틀간의 이번 학술대회를 통해 지식재산권에 관한 좋은 재판을 구현하기 위한 다양하고 많은 지혜가 모아지길 기대합니다. 저는 여러 나라에서 찾아와 준 법관과 전문가 여러분을 따뜻한 우정으로 환영합니다. 이번 국제 컨퍼런스를 통하여 서로가 뜻을 나누는 친구가 될 것으로 확신합니다. 앞으로 국제 특허법원 컨퍼런스가 더욱 발전하여 세계 지식재산 전문가들의 교류와 소통의 중심이 되기를 희망합니다. 다시 한번 2022년 국제 특허법원 컨퍼런스의 성공적인 개최를 축하드리며 이번 컨퍼런스에 참가하신 여러분 모두의 건강과 행운을 기원합니다. 감사합니다.
네, 감사합니다. Today we are joined with distinguished guest Kwang-hyung Lee, President of Korea Advanced Institute of Science and Technology, has attended. He is also President of Preparatory Committee concerning turning Korea into a World IP Hub. 오늘 귀한 손님께서 행사를 축하해 주시고자 참석해 주셨습니다. 이광영 가이스트 총장님의 축사가 있겠습니다. 이광영 총장님은 현재 세계 특허허브 국가추진위원회 공동대표이십니다.
Good morning. I am Lee Kwang-hyung, President of KAIST. I extend my deep congratulations on the opening of the 8th International IP Court Conference, a venue to discuss main issues in the global IP law arena. I have been taking part since the very first conference. I didn't miss a single one. So it has a very special place in my heart. Under today's theme of court IP and new practice, we are joined by IP field judges and practitioners from around the world. And I thank Chief Judge Kim Yong-seok of the Patent Court of Korea for putting together such a meaningful event to discuss IP. IP is the source of business competitiveness and an essential asset of the national economy with great significance. I am personally deeply invested in IP. Since about 8 years ago, I have been part of the National IP Committee and Supreme Court IP Hub Court Committee, National Assembly Global IP Hub Nation Committee, and the Patent Court Judicial Administrative Advisory Committee. Through such activities, I have contributed to establishing jurisdiction consolidation of patent cases, international tribunal, punitive treble damages system, and order to produce documents, and I take great pride in that. Today, In fact, we are seeing much difficulty in activities of our hub committee due to COVID pandemic. And some are concerned that proceedings cannot be conducted well during the pandemic, and we have vowed to improve the situation. Today, from 7 countries, including the US, UK, Germany, Japan, China, Australia, and Korea, we have IP judges and leading practitioners at today's conference, and I hope this time will serve to enhance our IP-related capabilities and expertise. I hope the IIPCC will continue to serve as a venue for global networking where countries gather to share IP-related wisdom and experiences. Once again, deep congratulations goes to the opening of the 8th International IP Court Conference. Thank you.
좋은 말씀 감사합니다. The Patent Court has received several videos of congratulatory remarks from the heads of prestige IP institutions around the world, wishing us a successful event out of their busy schedule. 다음으로 세계 유수의 여러 지식단체장님으로부터 축하 영상을 시청하시겠습니다. 다들 바쁘신 일정에도 불구하고 이번 컨퍼런스의 성공적인 개최를 희망하는 마음으로 영상을 보내주셨습니다. Without further delay, we are going to watch 5 videos. First, let's listen to the remarks of Lisa Georgeson, Deputy Director General of WIPO. 먼저 와이포 사무차장님의 축사를 시청하시겠습니다.
Honorable Chief Judge Yong Sok Lim, Professor Kwang Hyung Lee, distinguished judges, dear friends. It's a great honor for me to address you at this 8th edition of the International IP Court Conference, and I would like to sincerely thank the Patent Court of Korea for the invitation. Addressing the members of the judiciary is always a humbling experience, and as the functioning of any intellectual property system is relying principally on courts and the judges that sit on the bench. After all, IP rights are nothing more than a promise from the government that in case of unauthorized use of the subject matter under protection, be it an invention, a distinctive sign, or a work of art, the right holder will be in a position to seek judicial remedies. This is not to say that the job of IP offices administering the rights is not equally important, and statistically speaking, the number of litigated cases are by nature lower than that of processed applications of granted rights. Yet, courts represent the safety valve of the system, without which IP rights would simply not work in the intended way. All the functions of the IP system, including fostering creativity and innovation, disseminating technological information, providing a competitive edge, and a means for businesses to thrive, as well as serving as a legal vessel for technology transfer. All these functions presuppose that the exclusivity conveyed by IP rights is guaranteed by the courts. Consequently, the crucial role of the judiciary comes with great responsibility. Judges need to strike the right balance between the interests of right holders and the general public. While doing so, a remarkable degree of adaptability is called for. Working at the forefront of cutting-edge technology requires utter circumspection and an understanding of the wider policy implications of deciding a case one way or another. Allow me to begin with a short account of the refocusing of priorities that WIPO is going through. As the UN Agency for Innovation and Creativity, WIPO's mission is to support all of our 193 member states to use IP as a powerful catalyst for jobs, investments, business growth, and ultimately, economic and social development. That is why we are transforming our work to go beyond the technical aspects of IP to encompass the developmental aspects of IP. In accordance with our global partners, we are building a more inclusive IP ecosystem that engages not just with IP experts and professionals, but also with women, youth, entrepreneurs, startups, SMEs, researchers, indigenous peoples, and other communities around the world. A couple of words on the innovation landscape. Today's market is marked by the globalization, economic integration, and digitalization of innovative and creative activities. Value chain and distribution networks, digital and otherwise, are permeated by cross-border movement of intangible capital, notably in the form of IP-protected technology, design, branding, and cultural works. According to the World Intellectual Property Report released by WIPO in April this year, digitalization is the new big innovation revolution. Digital innovation quadrupled in the 20 years up to 2020, when it represented 12% of all patent applications, with a 13% annual growth rate. New technologies are leveraged to achieve economic development at a large scale. This is especially true in Asia, which is now the main engine of global IP growth. By 2020, Japan-based innovators held 25% of the world's ICT-related patents, followed by the Republic of Korea with 18% and China at 14%. At this point, let me also congratulate the fantastic city of Daejeon, the venue of today's event. According to the recently published Global Innovation Index for 2022, it has been ranked number 3 in the list of global science and technology clusters, which is an amazing achievement and surely the result of sound innovation and intellectual property policies in the Republic of Korea, as well as the hard work of the stellar researcher community. There is a multitude of factors that cause radical changes in the world we are living in. Some of those, such as scientific breakthroughs and emerging technologies, offer new possibilities. On the other hand, many of those are posing challenges for the entire humanity. Think of climate change or health-related crises, such as the latest COVID-19 pandemic. The good news is that new challenges bring about new solutions as a result of the inherent nature of humankind to innovate. Such new solutions, in turn, may pollinate other technologies and bring about solutions to problems that had not been able to be tackled before. Just think about it. Vaccine development for the prevention of the spread of the COVID-19 pandemic may be the cradle of a host of new medicinal products against very different ailments. Intellectual property is supposed to incentivize innovation. At the same time, global challenges spur new discussions, and the discourse around the IP system has surely changed over just the last few years. With a sharpened focus on fair access to life-saving technologies and the public funding of seminal research projects, IP rights need to showcase another aspect that is often overlooked: its potential to become a vehicle of technology transfer and a sharing of knowledge in a manner most conducive to the public good. This is a balancing act between keeping the reward mechanism functional while encouraging socially beneficial openness in many regards. Perhaps not surprisingly, courts have a seminal role in breathing life into the policy choices made by legislators in the individual countries. WIPO is an exceptionally good place to serve as a convener and a neutral forum for discussions aiming at the progressive development of the international IP system. Recognized by the international community as such, its various bodies, including the Standing Committee on the Law of Patents, facilitate the discourse around clusters of interlocking issues on both a practical and on a policy level. On top of that, as shown by your own example today, WIPO is also ready to partner up with relevant organizations in the promotion of a balanced intellectual property system around the world. For centuries, keeping sensitive information confidential has been a known feature of business life and a means of protecting intangible assets. In recent decades, trade secrets have evolved to become an important element in innovation and knowledge sharing through their legal protection. Factors such as the globalization of R&D and supply chains, the development of collaborative innovation models, and continued digitalization have moved trade secrets much closer to the center of our economies and growth strategies. The protection of trade secrets has its roots in the area of preventing unfair competition, a theme of this conference. Maturing into a form of intellectual property, trade secrets have earned their place in the ranks of important business assets. Their subject matter and legal protection may have different characteristics than those of patents, yet these two tools may complement each other well when it comes to building an IP strategy for a modern world enterprise. In the meantime, on a policy level, there needs to be a realization that a strong regime of protection for undisclosed information is essentially a judicial means against misappropriation of confidential information. This in turn entails, to a certain extent, counterintuitively, that robust trade secret protection systems may indeed facilitate smoother knowledge sharing between parties, contributing to effective technology transfer and open innovation. After organizing the second symposium on trade secrets and innovation in May of this year, WIPO will continue to offer an international forum for deepening a global conversation on trade secrets and innovation, which is expected to be a topic that will gain even more attention around the world from all business sectors. At the same time, the innovation ecosystem is coming under increasing stress. This includes the judiciary, who plays an important role in the IP ecosystem by providing predictability for market structures and alleviating commercial uncertainties. Let me share some illustrations of this. First, the rapid technological change raises questions on the boundaries of innovative activities as patentable subject matter. The World Intellectual Property Report states that computer and related innovation tripled in 35 years through 2000, when the sector represented 24% of all patents. This resulted in courts around the world engaging in reflections on fundamental questions regarding invention and computerization, and the application of legal tests to the question of patentability of computer-implemented inventions. Now, with the rapid growth of artificial intelligence, or AI, technology, courts are faced with cases in which patent protection is sought for inventions deemed to have been generated autonomously by AI, thus requiring judges, in their role of reviewing the decisions of IP offices, to examine the fundamental boundaries of inventorship in their national patent law. Second, courts face similarly difficult considerations when deciding on alleged patent infringements involving technologies that were not foreseen at the time the patent was filed. This phenomenon requires rigorous application and interpretation of the doctrine of equivalence and sufficiency of disclosure. Third, IP disputes frequently involve complex issues cutting across multiple legal domains, and the multi-territorial nature of technology exploitation increases tension with the territorial nature of intellectual property rights, as well as the principle of domestic judicial resolution. These areas of tension are particularly exposed in disputes involving standard essential patents. To a growing extent, the global market of technology products is affected by a web of territorial patent rights, covering inventions without which standard compliance cannot be achieved. The licensing framework of such patents inevitably brings about aggregated rates and cross-border issues. We are seeing a significant number of lawsuits filed in multiple jurisdictions with an overlap of rights invoked. These proceedings do not only involve patent law, but also need to balance considerations of competition law, contract law, and more for the courts to decide. Additionally, the judicial trends and practices applied by the different jurisdictions are now being scrutinized through the lens of international trade law. WIPO is currently closely monitoring the lay of the land in the SEP domain and the developments in its member states. At the same time, it is working on identifying those areas where WIPO may serve an important function as a global and neutral body with a central role at the heart of the international patent system. In these times, where innovation takes place at an accelerating speed and courts stand at the frontiers of law, judges and courts may benefit from engaging in cross-border judicial dialogue to garner ideas and insights from their judicial peers in other jurisdictions and at international meetings, such as this IP Court Conference. Such cross-pollination of judicial approaches will not only help in finding commonalities, but also in understanding differences. WIPO, as the global and neutral forum for intellectual property, is committed to facilitating such free exchange of experiences, expertise, and perspectives. WIPO looks forward to continuing its collaboration with the Patent Court of Korea and all other IP stakeholders participating at the conference in driving the development of a balanced and inclusive global IP ecosystem. Thank you for your attention, and I wish you informative and inspiring discussions over the next 2 days. Thank you.
네, 감사합니다. Next video is from the President Ichiro Nakatomi of LESI. 다음으로 국제 라이센싱 협회 나카토미 회장님의 축사를 시청하시겠습니다.
Hello, I'm Ichiro Nakatomi, current president of Licensing Executive Society International, LESI. It's my pleasure to address the judges and attendees of this year's International IP Code Conference hosted by Patent Court of Korea. Your theme this year is Code, IP, and New Practice. It's particularly a unique time for all of us to discuss these issues as many countries continue to recover from COVID-19 pandemic. In the past few years, we have witnessed some fundamental shift in how business operate and look at the future. This has affected how people connect, travel, and prioritize their work. It has also affected some companies' investment in technology, what partners they choose to collaborate with, and how they might value for their intellectual property. There are some topics that we have discussed at LESI and among our members throughout the world. I thought I might introduce you to organization and some of the activities we support. LESI is a global network of licensing professionals established in 1973. We are celebrating our 50th year of convening our members and the public to discuss, to create, protect, and commercialize innovation. In doing so, LESI advances the business of intellectual property to enable investment in new technologies and bring those technologies to the marketplace. Our experts can discuss the finer points of IP business and the value of IP from negotiation to dispute resolution. LESI consists of 6,500 individuals, members from 33 societies in 90 countries, largely from Americas, Europe, and Asia regions. Thailand has recently joined, and Vietnam is expected to be established in the coming year. LESI is governed by 12-member board member of directors, 2 legal counsel, and executive director. My theme this year as LESI president is sustainable innovation and sustainable collaboration to support IP business goals. This means that no matter how good a discovery or technology is, it will not last without collaboration. This is core to work that all LES members globally engage in and is even more important as a result of the pandemic. We witnessed incredibly fast development of vaccines and distribution methods to address the COVID-19 pandemic. This global response could not have been accomplished without investment in the underlying innovation for years before pandemic and without parties coming together to share and utilize these innovations. IP rights have enabled and continue to enable many of these collaborations by helping parties come together and by mitigating the risk of investors and companies to invest high-risk technology development. For LSI, this also means operating their organization from the business perspectives to drive membership and engagement. Among other things, we are actively promoting collaborations for LSI and local LAS societies with external organizations in addition to the internal improvements. I've listed a few of our activities this year. Several new LASI committees have been formed, and this year, notably the SDG IP Index committees, ranking of companies based on sustainable development goals, SDG, and environmental, social, and governance goals, ESGs, do not currently take into account the value of IP, which is an intangible asset that companies rely on. So consistent with my theme for ADSI, we are developing a tool that highlights these points, and we'll be announcing this ranking next year at our LASI 2023 annual meeting in Montreal. This year, we are also launching a new initiative, LASI Thought Leadership Program. We're hosting a series of online webinars addressing these specific topics, which then culminates in an annual conference session. The topics of 2022-23 are SEPs, standard essential patents, and automotive industry and dispute resolutions. The first session will address SEP and will occur on October 25. ADSI holds its annual conference once a year in the spring. In 2021, we had hoped to hold our meeting in Seoul, but due to COVID, we hosted a virtual meeting. This year, we are able to return in-person meeting in Venice, Italy. More than 500 people gathered. Just last week, we asked some of our organizers to gather again to provide executive summary of the event. The session allows public and LAS members who are unable to join the meeting in person to nonetheless benefit from various conversations. Next year, in 2023, we are in Montreal, Canada, starting April 30th. We are trying to make it accessible to all professionals, scientific universities, industries. So you have the opportunity, please join us. Thank you for letting me introduce LSI to you, and I wish you good luck for successful conference. Thank you for your attention.
네, 감사합니다. 여러 단체에서 축사를 보내주셔서 축사가 좀 많습니다. 많은 축사를 보내주셔서 감사하게 생각하고 있는데
We've received
다음
many
축사를
congratulatory
보시겠습니다.
remarks, so
The next
I'm
video,
very grateful.
The very next video is presented by President Shoichi Okuyama of AIPPI. 다음으로 국제지식재산보호협회 오쿠야마 회장님의 축사를 시청하시겠습니다.
My name is Shoichi Okuyama, President of AIPPI
안녕하십니까. 저는
International.
쇼이치 오쿠야마
I'd like to congratulate
AIPPI
you
회장입니다.
on the
한국
opening
개전에서
2022 International
2022 국제
IP
특허법원 회의를
Conference
개최하시게
in
된 것을
Beijing,
진심으로
Korea.
축하드립니다.
I also like to thank the
그리고
organizer for
이토록
giving us this
저명하신
opportunity
발표자들과
to
귀빈
speak
여러분들
in front of
앞에서
distinguished
축사를 드릴 수 있는 기회를
and the
주셔서
audience.
주최 측에게 무척
With the
감사드립니다.
participation of judges
영국,
scholars and practitioners from
미국,
United States,
독일,
Germany,
호주,
England,
일본, 중국,
Australia,
한국의 판사들이
China, Korea,
참석하여
and
개최되는
Japan.
이번
This is a truly
행사는
international
진정한
event.
의미의 국제적인
As we
행사입니다.
all know, the
법원은 다 아시다시피
courts are the last resort for the
지적권의
proprietors
소유자들이
to
지적권의
obtain legal
침해와
relief
또 부당
against
경쟁 행위에
IPR
대한 법적
infringement
구제를 받을
and
수 있는
unfair
최후의
competition violation.
보루입니다.
The proprietors has to rely on
지적권자들은
the
법원의 소송
transparency
절차의
of court
투명성에
proceedings
의존하고
and also
그리고 법원의
consistency of
일관성
court
있는
judgments
판결을 통해서
to protect their valuable IP assets. The harmonization of IP enforcement procedure and substantive legal standard is of paramount importance for corporations which carry out business without knowing country borders. We are sure that this conference will be successful in exchanging ideas and elucidating differences that proprietors encounter when they conduct cross-border litigation. The audience will learn issues related to damages calculation and also issues related to trademarks and unfair competition. I'm sure this conference will be very fruitful for providing the opportunities, learning opportunities for all the participants. AIPPI has 8,000 members covering more than 130 countries with a history of 125 years. The AIPPI has spearheaded harmonization effort as a leading international organization of lawyers, patent attorneys, corporate managers, and scholars. For example, this year in San Francisco Congress that was held in September, we studied 4 questions. First, patentability of diagnostic method. Second, protection of trade secret in civil proceedings. Third, trademarks and internet and social media. And fourth, moral rights in copyright law. In the end, we had 4 resolutions as agreed by all AIPPI members. This is a year-long effort on the part of AIPPI. We ask all national and regional groups to submit national reports, and we collect something like 40 national reports. And on the basis of those national reports, we come up with draft resolutions. Draft resolutions are deliberated by different stages and before plenary sessions and made into AIPPI resolutions. AIPPI discusses these resolutions with WIPO, EPO, and EU IPO, as well as with national patent offices. Let us look into some details on these resolutions that are concluded this year. On the issue of patentability of diagnostic method, AIPPI resolved that diagnostic method should be patent eligible, and also noted that the methods and uses involving diagnostic decisions based on 1 or 2 or more biological parameters should also be patentable, with the proviso that some countries may exempt medical practitioners from patent infringement. For the protection of trade secrets during the civil proceedings, while many countries are noted to have some protection over trade secret, harmonization is far from being reached, and AIPPI called for renewed effort towards such a harmonization. In the moral right resolution, AIPPI resolved that moral rights should be available on all types of works, and outlined the recommended nature of moral rights. In the resolution of trademarks and internet and social media, the AIPPI resolved that the use of trademark on the internet or social media should be a use of a trademark. In doing so, metaverse and NFTs were excluded from discussion for now. AIPPI have these and past resolutions made available to the public, and all relevant documents are also available to the public without membership. So please visit our website and click library button at the top of the page. With the very capable renewed function of search, you can find very useful and rich resources for comparative law studies. Well, we hope that this Korean conference will be fruitful for all the participants and also help the users of IP system understand the intricacies of IP infringement litigation. Thank you very much for listening.
감사합니다. President Roberto Pistolesi of FICP also sent us his remarks. 다음으로 국제 변리사 연맹 피스톨레시 회장님의 축사를 시청하시겠습니다.
Estimated judges, first of all, I would like to thank all of you for inviting FICP, the International Federation of Intellectual Property Attorneys, to participate in this International IP Court Conference. My name is Roberto Pistolesi. I am an Italian and European trademark and patent attorney, and I have just been elected president of FICP during the World Congress that was held in France, more precisely in Cannes, from last 25th to 29th September. This is therefore my first official appearance in this capacity, at least at the time of recording the present message. Consequently, as you may imagine, I am pretty excited and also quite sorry for not being able to attend in person. I would have been, in fact, very interested in physically attending this event, not only because I am now the president of FICP, but also because, as a patent attorney, I am specialized in chemical and pharmaceutical patents. And in this specific capacity, I am one of the technical experts that are appointed by the IP specialized courts of Milan and Venice in Italy, where I try to assist the local judges in reaching their decisions in patent validity and infringement cases. Consequently, knowing judges' perspectives is clearly very important to me. As many of you probably already know, FICP is the only international NGO whose membership consists entirely of IP attorneys in private practice. As a result, it is driven by a shared interest among like-minded people to promote common solutions and advocacy for private IP practitioners. Founded more than 100 years ago, the FICP global community has more than 5,800 members drawn from 86 countries and regions across 6 continents. Therefore, since FICP represents people from so many jurisdictions, an international IP court conference like the present one is really important for our community. As a matter of fact, harmonization is one of our goals. Harmonization not only, for instance, of patents and trademarks validity requirements, but also of court procedures and doctrine. As just explained, I am specialized in chemistry and pharmaceutical patents. Consequently, as you may imagine, I am really very interested in the doctrine of equivalence, where harmonization is far from being reached not only from country to country, but also if we consider different courts of the same country. This is something which is creating serious problems to me and to my colleagues, since sometimes it is very, very difficult to provide our clients with good and reliable advice about what they can reasonably do in nowadays global market without violating the patent rights of their competitors. So first of all, I would like to thank you if you were able to consider this aspect, if possible, during this conference. Secondly, I have noted that the theme of this year's conference is Court IP and New Practice. In this connection, a topic that is particularly relevant to the FICPIC community and which has been brought to the forefront by the recent pandemic is that of virtual hearings. Sometimes, as in fact in the case of the pandemic, virtual hearings are a necessity, and you cannot do without them. But sometimes they are not. The issue is therefore what to do in the new practice. FICPI has recently taken a position in this sense by filing an amicus brief with the enlarged Board of Appeal of the European Patent Office in case G121. The question that was referred to the enlarged board was essentially whether the conduct of oral proceedings in the form of a video conference is compatible with the right to oral proceedings if not all the parties have given their consent. FICPI's position was that the conduct of oral proceedings in the form of a video conference is compatible with the right to oral proceedings as long as attendance in the presence of the members of the division or board is offered to the parties, except, of course, when extraordinary circumstances such as public health emergency or security reasons makes attendance in person impossible. And this because, according to FICPI, a party's right to an in-person oral hearing is a fundamental principle of any judicial system. Consequently, according to FICPI, once the COVID emergency is over, parties should always have the right to attend oral proceedings in person, at least in inter partes proceedings, even if oral proceedings by video conference become a standard option in the future. Therefore, I would thank you if you could consider FICPI's position in your future activities. Lastly, I have noted that one of the subjects of this year's conference is distinctiveness by use of a trademark and the descriptive trademarks. In this connection, FICPI last year passed several resolutions which address similar topics. For instance, in 2016, it passed a resolution concerning the limitation of use of trademarks and trade dress. In that occasion, FICPI urged legislators to respect legitimate trademark and trade dress rights and to avoid imposing limitations on the use of such IP rights based upon the type of product and or service without demonstrating a compelling public interest to do so, which outweighs the rights of owners of such IP rights. And it further urged legislators, where such a compelling public interest is present, to ensure that limitations are neither disproportionate nor unreasonable. In 2018, FICPI also passed a resolution urging trademark offices to accept letters of consent and consider them in assessing confusion between marks. And in the same year, it passed another resolution concerning the examination of slogan marks, in which it urged national and regional trademark offices to apply the same examination standards to slogans and other word trademarks. Lastly, during our very recent World Congress, FICPI passed a very up-to-date resolution concerning non-fungible tokens, namely the so-called NFTs. In particular, FICPI urged trademark offices and legislators to provide guidance on the registration of digital artwork authenticated by NFTs, particularly in respect of ownership and proof of use, and to provide guidance on the classification of NFTs and or virtual goods associated with the NFTs. And finally, to provide guidance on the comparison of virtual goods with real-world goods during examination, opposition, and cancellation proceedings. This last and very recent resolution concludes my intervention in this important conference. I take this opportunity to let you know that FICPI is now organizing its 21st Open Forum, which will be held in London from 4 to 7 October next year. The forum will likely include a session concerning court-related issues. And if this is indeed the case, we might ask some of you whether they would like to join the session as speakers. For the time being, this is all. I wish you all the best for a fruitful and satisfying conference, and I hope to meet some of you in London next year. Good work and thanks.
감사합니다. 장시간 축사를 시청하셨습니다. 이제 마지막으로 국제상표협회 빙크 회장님의 축사를 시청하시겠습니다. The last video is from President Ziegler Vink of the International Trademark Association.
Good day, everyone. Thank you to the Korean Patent Court for organizing today's proceedings, and to the honorable judges from around the globe attending, and to the respected members of the Academy, intellectual property practitioners, to honorable judges from across the world, to respected colleagues and organizers with the Korean Patent Court. Thank you for inviting the International Trademark Association, INTA, to participate in this year's International Intellectual Property Court Conference and provide this message. First, let me underscore the important role of the judiciary and INTA's ongoing work around the globe. INTA works closely with judiciaries, including organizing forums and exchanges on best practices. We have a dedicated workshop for judges at our annual meeting, and ASEAN member states judiciaries have participated in these workshops for many years. Our goal is to nurture efficiency, consistency, cost effectiveness, and quality of decisions in trademark dispute. INTA is committed to cooperating with the judiciary to foster an effective IP jurisprudence and encourage interactive discussions between practitioners and the judiciary on cutting-edge IP topics. As such, INTA organizes workshops for judges, and this includes a judges workshop at our annual meeting and customized local workshops. These local workshops cover cutting-edge developments in IP case law and legislation. In doing so, they are helping the advanced judicial expertise on IP, and to date, judges' workshops have successfully been hosted in 13 countries across 4 continents. In 2023, we will see workshops in southern Brazil, India, Namibia, Nigeria, and Colombia in coordination with the Andean Community Tribunal. INTA and the judiciary is an important topic for us. Topics discussed during these local workshops are tailored to meet local interest and requirements. Past workshops have covered comparative review of general trademark prosecution principles, protection and treatment of well-known marks, non-traditional marks, administrative procedures such as oppositions, cancellations, and the appeals of these decisions to the courts, preliminary measures to protection such as injunctive relief, seizures before judgment, community law and the implementation by national courts in the Andean community, counterfeiting and the legal enforcement measures to address it, and international IP treaties and their implementation and execution. In several jurisdictions, our workshops were endorsed or co-hosted by local supreme courts and the official judicial academies or universities. Feedback received from these events is very encouraging, and in many cases we are asked to repeat our engagement regularly. A priority advocacy issue for INTA in recent years has been bad faith filings and the adoption of best practices to combat this abusive practice. Policy dialogues and engagement on bad faith filings and registrations have successfully been hosted in China, the Philippines, and Thailand. INTA is also taking a major role in the current discussion surrounding the EU IPO CP13 on bad faith filings. Another key issue right now is injunctions. There is a lack of harmonization regarding the availability and requirements for injunctions, and we would like to see this addressed in policy dialogues. Notably, INTA represented before the WIPO Advisory Committee on Enforcement in September, marking a major milestone towards raising awareness of the lack in harmonization. Harmonization of opposition procedures is another key focus area. A worldwide survey of opposition practices revealed harmonization deficiencies in all regions. We plan to raise this matter through policy dialogues. Potential target countries in the ASEAN region are Myanmar, Thailand, and possibly also Vietnam. Future projects include the review of policies and treatment of use of trademarks online, assessment of the importance and use of coexistence or consent agreements in IP prosecution and litigation, and local issues such as different legislative initiatives in China, India, and Indonesia. As I noted, we host a judges workshop at our annual meetings, and we're very excited to be bringing our annual meeting back to Asia next year. In 2023, our annual meeting Live Plus will take place in Singapore in person on May 16 to 20, and virtually from June 27 to 29. We hope that you will be able to join us. Once again, thank you for the opportunity to provide this video message. We wish you all a productive and enjoyable program today. Thank you.
감사합니다. I would like to thank all of them for giving us a heartfelt congratulatory remarks. 축사해 주신 모든 분들께 깊이 감사드립니다. It's time to wrap up the open ceremony of 2022 IBM PCC. Now we are going to prepare the stage for the session 1 and we will begin shortly. Please remain in your seats while the stage is set up. 이것으로 2022 국제 특허법원 콘퍼런스 개회식을 마치겠습니다. 연단을 정리하고 바로 1세션을 시작하겠습니다. 연단을 정리하는 동안 자리를 지켜주시면 감사하겠습니다. 제1세션 연사들께서는 미리 연단에 나와서 준비해 주시기 바랍니다. 연단 세팅을 먼저 하겠습니다. Before the commencement, let me briefly explain about the reference book. 세션 시작하기 앞서 오늘 받으신 자료집에 대한 설명을 잠시 드리겠습니다. There are 3 books which is prepared with great care by moderator, panelists, and members of the organizing committee, published both in Korean and English. You may find the first session and mock arbitration in Book 1, while the second and third sessions, as well as the material prepared by Patent Korea's practice study group, are brought together in Book 2. The Book 3 contains Session 4 as well as material from the Patent Korea course practice study group. The reference books are edited along the sequence of the conference and presentation. Each session, except for the mock arbitration, will be proceeded with the question and answer. The contents of discussion generally will not exceed the scope of Q&A. Thus, during the discussion of the session, it would be very helpful if you would refer to these books to fully understand the discussion. 각 세션의 사회자와 발표자 및 저희 법원 준비위원이 정성스레 준비한 이 자료집은 3권으로 되어 있습니다. 1세션과 모의중재가 1권, 2, 3세션 및 특허법원 실무연구의 자료가 2권, 제4세션 및 실무연구의 자료가 3권입니다. 또 모의중재 세션을 제외한 각 세션은 질문과 답변 순서로 이루어져 있습니다. 논의될 내용은 대체로 Q&A의 내용을 벗어나지 않을 것이므로 세션에서 논의가 진행되는 동안 자료집의 Q&A 부분을 참고해 주시면 논의 내용을 깊이 이해하시는 데 큰 도움이 되겠습니다.